Hello again, everyone. This is the AM show, Wang Law Office's newest YouTube show. And I am Victor Manibo, one of the lawyers here at Wang Law Office. This is our third episode, and I'm excited to talk with you all again and answer your questions.
Hi, I'm the host Ariel. Also, I'm a senior paralegal in Wang Law Office. Our show is going to start every Friday at 8 a.m. EST.
Yes, so during those times, make sure to catch our show and just go to our YouTube page, okay? And like the previous episodes, this show is going to be a series of questions that are common to our immigration audience, like most frequently asked questions. And we try to get our questions through YouTube. So if you're watching this and you have questions, you can post a comment. You can also email us or message us through WeChat or Line.
Yeah, Victor, can you introduce yourself a little bit?
Sure. If you haven't seen our previous episodes, my name again is Victor Manibo. I am a senior attorney here at Wang Law Office. I mostly do immigration cases and sometimes some criminal cases that impact someone's immigration status. I've been working for the firm for almost 10 years. I've been a lawyer for almost 12 years. I graduated from Cardozo School of Law here in New York. And, I'm just happy to be able to help this community and hopefully through answering your questions, we can guide you and help you out with your immigration problems.
Yes. Last time we discussed family-based green card. However, there's more questions we didn't cover. So we continue this topic again today. So my first question is, what are the exceptions to the I-485 application requirement of maintaining lawful status in the U.S.?
Okay. So last week we talked about adjustment of status and how, the word adjustment means you're changing from one status to another, right?
Yeah.
And that means for people who are adjusting status, a lot of them already have legal status in the US. Maybe they have a tourist visa, a B visa, or maybe they have a student visa or any other form of status to stay, and then they're adjusting to get lawful permanent residency or LPR status, or adjusting to get what we call a green card, right?
Mm-hmm.
Now, once you file your I-485 application, sometimes it takes a while for that to get decided. I think we discussed that last week, right?
Mm-hmm.
Sometimes it can take over a year, depending on a lot of factors. And one of the requirements under the law or under our immigration rules is that you should be in lawful status while your I-485 is pending. And for some people that might be a problem because maybe their status has a certain expiration date or it's at a certain time, right? So this question that we got is asking who are the people who don't have to worry about that? Like who are the people who don't have to maintain their lawful status? Like, even if they're waiting 2 or 3 years for their I-485, they don't have to worry about maintaining their lawful status. Well, those lucky people are, the IRs, the immediate relatives. We talked about that last week. If a family member is classified as an immediate relative, they don't have to maintain their lawful status. Even if let's say their tourist visa expires, it doesn't matter. The I-485 is still going to be processed. It's not going to be a problem for you. You won't get what's called unlawful presence, which we talked about last week. Other types of people who don't have to worry about maintaining their lawful status are foreign medical graduates, special immigrant children, and some immigrants who have served in the U.S. military. But those are usually the rare cases. Yeah, special cases. We don't really hear about them a lot. Most of the people who are listening in or who ask those questions are those who are family-based, right?
Mm-hmm.
And for them, like if you're an immediate relative, you don't have to worry about maintaining your lawful status.
So can I change my address with USCIS? Whether it's going to affect my family-based petition?
Right. So this is again part of like things that that people think about when their I-45 is pending, right? And like I said, it can take a long time. So some people move while their I-45 is pending. If you have a pending application with USCIS and you move, first of all, you should inform your lawyer. Hopefully you have a lawyer helping you out with this, because like I said, and I keep saying this, it's important to hire representation who knows, a lawyer who knows what they're doing. This is not an easy form to fill out. So if you're changing your address, inform your lawyer and inform USCIS. If you have a lawyer, your lawyer should be able to help you change your address with USCIS. Some people can do it online through the USCIS website. I don't advise doing that. If you have representation, you should have your lawyer do that for you. But yes, the answer is you can change and you should change your address with USCIS. Now, whether or not that'll affect your green card, it won't affect whether it's going to be approved or denied. It's just, USCIS just has to update their file. It might cause a little bit of delay because obviously things are changing about your case. It changes where your case has to be decided or where your interview might be scheduled. But other than that, there's no big effect of changing your address.
So what if I want to go back to my own country when my I-485 is pending? Can I adjust my status on my home country or after this I-485 is filed?
Okay, so when we talked about adjustment of status last week, we said that it's a path to getting a green card for people who are in the country, right?
Yes.
If you're outside of the country, you're going to do it through consular processing. Now, this question is about your I-485 is pending and you want to go back to your home country and you want to just get your green card from outside. You change your mind, for example. People change their minds, that's okay. What happens? Can someone do that? Well, if you leave the country, your I-485 application, your adjustment status application will be deemed abandoned. Meaning, as far as USCIS is concerned, you gave up on your case. It's gone, goodbye, right? I think we talked about advanced parole last week. We talked about, how you can travel in and out of the country while it's pending. This question is different. This is like, oh, I just want to get my green card from outside the country, right? So I-485 is abandoned if you leave. Now, can you still get a green card? Can you still get a green card through consular processing? The answer is yes, but it's going to be a longer route, longer than getting an I-485 approved. Because going back to our episode 2 weeks ago, you have a petition, you have a petitioner from a relative, right? You can still use that for your consular processing if you leave the country, but that I-130 has to be sent to the consulate. And for that to happen, you have to file what's called an I-824, which is another application, which is another form that needs to be decided before you can have your petition sent to the consulate. And sometimes that takes a long time. So the short answer to this is like, yes, you can still, on the basis of that petition, you can still pursue a green card outside the country. It's not an I-485 anymore. It's going to be consular processing, and the process is going to be a lot longer.
So if I'm on the process of filing this I-485, do I need to report my prior arrest record in the US or in anywhere in the world?
Okay, so criminal arrests or anything that has to do with the criminal justice system. Say somebody was arrested, or they were found guilty of something, not just arrested, but they went to court and they lost their case, for example. If that arrest or that conviction happened before you filed your I-485, you have to say that in your application form. The form I-485 actually asks about arrests and convictions or anything that has anything to do with the criminal justice system. So if it's before your I-485, you have to include that there. Now, if you, for example, your I-485 is pending, and then you get arrested while it's pending, or you have a criminal case while it's pending, you're going to have to inform USCIS about that eventually. Usually that happens during the interview, and we can talk about the interview more later on. But while your I-45 is pending, you should declare changes like that with the USCIS. Your attorney is going to be able to tell you the best way of presenting that new information to USCIS. But the short answer is yes. If during the wait time for your I-45, I don't know, you get into a car accident and then you're arrested by the cops or something like that. Maybe you did something bad. Hopefully not too bad. You have to let USCIS know. And the reason is because any criminal conviction might affect your eligibility. Like if it's a bad enough kind of case, you might get denied. And this is not something that you should be hiding from USCIS. So, we can talk about that more in another show because there's a lot of questions about
too much detail.
Yeah, but the answer is yes, you should tell USCIS. It depends on the case, on how best to present that information to USCIS.
I know that in the 45 application, we need to do a medical exam. How long is my medical exam result going to be valid?
Okay, so for the I-485, you have to submit together with that form of what's called an I-693. It's something that a doctor signs to say that you are a healthy individual, that you don't have any contagious diseases, right? We talked about this last week. And there are two deadlines you have to keep in mind. One is, when should the doctor sign? So the doctor should sign that I-693 form no more than 60 days before you file the I-485. Okay? So, you can't, if you get the I-693 signed, you can't wait too long to submit the I-693 together with your I-485. You only have 60 days. So that's one thing you have to think about. Second thing you have to time frame that you have to think about is the validity. Does the I-693 expire? In the past, generally it expires after 2 years. After 2 years, if your I-485 is pending that long, you might need to redo the I-693 again and ask the doctor to fill out another I-693 form. Now, that was in the past. Recently, USCIS changed their regulations to say that an I-693 has a 4-year validity, so it won't expire for 4 years. And the reason for that is because of a lot of delays during the COVID pandemic and because of the backlog in USCIS. We know that a lot of cases aren't getting decided pretty quickly. Some cases do take 4 years. So it's better now for applicants because they don't have to worry about, my I-693 is going to expire. I have to get another one and then submit it again to USCIS.
So this new policy, when did it come out? Who going to benefit from this policy?
Right. So it's a recent policy. Like I said, it only was implemented around the fall of last year, August 2021. So this affects everyone who has to deal with I-693. And there are specific dates that you have to keep in mind. Like I said, the 60 days. But other than that, this is just a new rule. We don't know if they're going to change it in the future.
So where to file this? When the I-485 is pending, where to file to submit another I-6?
Okay. So for example, again, because your I-485 is pending such a long time, right? And you submitted an I-693, and then you know that it expired because oh my God, my case has been pending for 4 years. I know my I-693 is expired. I should get another one. I would suggest not just getting right away on your own. Don't just do it. You have to wait for USCIS to tell you to do it, and that happens when sometimes you get a letter. It's called a request for evidence or an RFE, and that's USCIS's way of telling you, hey, you have a missing item. I need you to get this and submit it to USCIS. So if your I-693 expires, if you know that your I-693 is about to expire, don't do anything yet. Wait for USCIS to tell you to submit it, and they will have instructions on that RFE on what you need to submit and where you need to submit it.
You just mentioned RFE, right?
Mhm.
How do USCIS decide an I-485 application?
Okay.
RFE.
Right. So RFEs it's part of the decision-making process of USCIS. When you submit an I-485, you have all these forms, right? You have all these supporting documents, and it's usually a thick package. I told you before, like the more evidence you have, it's usually better. But sometimes people forget to submit things, and people have missing information in their package. So USCIS, as a part of their decision-making process, they issue what are called RFEs, or requests for evidence. It's a letter from USCIS saying, hey, you're missing a certain thing. You're missing a certain item. You're missing a valid I-693, like we were just talking about, because your I-693 expired. Please submit it to us, or please bring it to the interview. They'll instruct you on what's missing and how you can submit it to USCIS. So that basically is the short answer on what an RFE is.
So if I receive an RFE during this application, and then do I have to reply it? What should I do?
Okay, so what should you do? You get one of these letters, right? First is like, don't be scared. It's not, it's not a bad thing. It's just part of the process, right? Sometimes some things are missing, and USCIS just wants to get all the information. So this is their way of getting more information from you. If you get one of these, and if you have a lawyer, talk to your lawyer about it. But just so you know, what the RFE usually contains are a few things. One, it's saying what you're missing, what missing items you have. Two, how to submit it. Like, do you have to mail it to a certain office of the USCIS? Do you have to bring it to the interview or something else? And three, it has a deadline. It tells you when you should submit the missing item. So yes, the answer is yes, you have to respond to an RFE. How you're going to respond and when you have to respond depends on the contents of the RFE. It differs. Usually it's like 30 days. Sometimes it's 60 days you have to respond. Sometimes you have to mail it in to the USCIS office. But those are the typical scenarios. You have to read it carefully to make sure that you're complying with those instructions on the RFE.
So I heard the word NOID, the notice of intent to deny. If I receive this kind of notice, what should I do?
Okay, so a notice of intent to deny is another letter that you might receive while your I-485 is pending. It's called a NOID, N-O-I-D, or notice of intent to deny. And, listening to those words, notice, meaning it's a letter, right? Intent, meaning plan, like, they're trying to, or USCIS is intending to deny. So that's kind of scary. Like, USCIS is thinking of denying my case. That doesn't sound good. And, it kind of is not a good thing. And this is why you need a good, competent attorney, because once you get one of these things, it means that USCIS has found something bad in your case, something that will disqualify you from getting your green card. So these letters are important. But it's also kind of like an RFE in that it tells you, like, hey, you have some missing things, or there are these problems in your case. And that it tells you what you need to do. You need to submit more evidence. You need to submit, sometimes you need to submit a brief or like a legal argument. Sometimes it's just, more documents than you already submitted. And then three, it also has a deadline. It tells you when you should submit your response. So the quick answer is yes, you have to respond to this. This is more serious than an RFE. I mean, you have to take both of these things seriously. But an NOID is usually more serious and more complicated. I hope you have a lawyer to help you out with that. And if you don't, you should find a lawyer to help you out with that.
You keep mentioning a lawyer. So if the lawyer going to receive the same NOID or RFE as the client?
Right. Yes. Generally, if your lawyer filed all the paperwork correctly, all the notices that everything that USCIS sends to you will also be sent to your attorney. So both of you will be getting copies of all these documents.
I know everyone going to worry about interview. Is an interview going to require for the adjustment of status?
Yeah. So the short answer is Generally, yes. Most, if not all, green card applications via I-485 will have an interview with USCIS. It's only in very, very specific cases that an interview is waived, meaning you don't have to go. But if you're a family-based applicant, then that's what we're talking about, right? Family-based petition. 99% of the time, you will be asked to go to an interview at USCIS where you meet with an officer, and the officer asks you questions and decides whether or not to give you a green card.
So what should I bring to an interview?
The interview starts when you get an interview notice. Again, this is another letter from USCIS, and that interview notice will tell you the date and the time of your interview and what you need to bring. It lists, typically it lists you have to bring valid ID, you have to bring, your proof of status, if you have an I-94 or like an entry documentation, you have to bring that. Any supporting documents that you already submitted with I-485, you will be required to bring the originals so that the officer can inspect them and look at them and make sure that everything is valid and correct. And documents that are relevant to the petition, right? So, for example, if this is a green card application based on a marriage, so documents that are relevant to that marriage, your marriage certificate to your spouse, your other documentation that prove that your marriage is real. These are the typical things that you have to bring to an interview. Every interview is different, but you should check what the notice says on what you should bring, and you should check with your attorney also, because your attorney might want to tell you to bring more stuff that's not on the interview notice.
So what kind of question going to be asked at the interview?
That also varies a lot. It depends on the officer that you're talking to. I mean, I've done a lot of these interviews, and no two interviews are the same. Everything is different depending on the officer and obviously depending on the case. Some interview officers ask a lot of very detailed questions. Some officers only ask questions about the problems in the case, if there are any problems in the case. So it's best to be prepared to answer all sorts of questions, everything that you've ever submitted to USCIS with the I-485, with the I-130. They could go through every question on those forms. They could go through every document that you submitted. But keep in mind that the goal of the interview is to see if you are qualified and if you are a good candidate to give a green card to. So with those goals in mind, that's what kind of questions the officer is going to ask.
What if my application didn't get approved at the interview? What to do?
Okay, so let's say you get an interview notice, right? And then you go to the interview, you bring all your documents, your lawyer's with you, and then the officer asks all these questions. You're there for like 2 hours. Sometimes, it happens. I've experienced that before. You try and answer everything. And at the end of it, the officer might say, okay, I'm denying your application, which is bad, right? Like, oh my God. Or sometimes they'll say, okay, we don't have a decision yet. We will let you know in the future. Sometimes, if it's good, they say, okay, it's approved. Then yay, great. Like, you're going to get a green card. What happens if they say it's denied? This happens very rarely, but if it happens, then you'll get another notice officially saying your I-485 is denied, and then you have to explore your options. We talked about this last week. What do you do if your application is denied? You can appeal, you can reapply. There are options for that. If it happens at the interview, then you know what you need to do right away. But you're still going to get a notice, and from that notice, usually you have a set number of days to appeal it or to file a motion to reopen, and usually that's within 33 days. Now, if after the interview the officer says, okay, we're going to get you a decision within a few weeks, then there's nothing to do. You just wait. Hopefully it will get approved. Usually it just means that the officer still has to review your documents again, and maybe consult with their supervisor.
So you mean a few weeks? How long going to take for a decision after an interview?
It depends. They usually say within 4 to 6 weeks, you'll be mailed the decision. Sometimes it's faster than that. Sometimes it's longer. It depends on the officer. An officer, like I said, sometimes they have to go through the documents again just to make sure that they didn't miss anything. Sometimes they have to consult with a supervisor to make sure they're doing the right thing. So there's no set time. I've seen approvals or decisions within like a few days, and sometimes it takes a few months.
So you mentioned if the 485 is denied, what to do?
Right. So with I-130 and a little bit last episode, we talked about options after a denial. Generally, you can appeal any denial by USCIS. With I-485s, you need to file what's called a motion to reopen or reconsider. You have to file another form, submit another package to USCIS so that their appeals unit, another like a higher sub unit in the agency, can decide whether or not the denial was correct. This is, again, something that you should not be doing on your own. Hopefully you have a lawyer who can help you out with this. But the bottom line is there are options. It's not the end of the line. There is an appeals process within USCIS for you to explore if your I-485 is denied.
So what if I appeal to this I-485 denial? Is the appeal office going to make a decision, just approve my green card, or my green card going to go back to USCIS, then do the process again?
Well, it depends. Generally speaking, they can do both. They can just approve it right away, or they can send it back to the officer to like redo the thing. You might have to redo an interview. You might have to resubmit some documents. It depends on the basis of the denial. And whether or not you can even reopen your case depends on the basis of the denial. So you identified two scenarios, right? Is it going to get sent back to the original office or officer, or is it just going to be approved? Both of those are possibilities.
Yeah, and today our time is up, so feel free to leave your question to us.
Oh, I mean, I didn't even notice it's been 30 minutes. Yes, if you have any questions, more questions about the I-485 process, family petitions in general, please send it to us by YouTube, commenting on our page, or like emailing us and messaging us on WeChat or Line. Next week, we will talk more about I-485s, but more specific topics of criminal cases for I-485s and how they impact your eligibility for a green card. So send in your questions about that soon. What else? Oh, as a reminder, this YouTube show is only to give you some insight on the process. It doesn't constitute legal advice. It doesn't constitute legal representation. I don't represent all our viewers. Please keep that in mind. But if you are looking to be represented by a lawyer, you can reach us. Our contact information is on the YouTube page. It's on our website, lawful.com.
Yeah, you can continue to follow us on YouTube. Thank you. See you next time.
Bye.